Hello everyone. Let us continue and resume our discussion on private corporations. In this session, we're going to discuss three main topics. First, we are going to talk about the powers of the corporation. Next, we are going to talk just very quickly about bylaws. And lastly, we're going to talk about meetings. Let's discuss the first topic in this session, powers of the corporation. Do corporations have unlimited and absolute right to exercise corporate powers? We have already learned when we introduced private corporations in the previous session that a corporation, as one of its attributes, can only exercise those powers which are either expressly provided for by law or incident to its existence. So the answer to this first question is no. Corporations do not have unlimited and absolute right to exercise corporate powers. This is because a corporation is a creation of the law, and it can only exercise those powers which have been conferred to it by law or which are incidental to its existence. This is what we call the doctrine of limited capacity. Why is this considered as the doctrine of limited capacity? This is because when it comes to powers of the corporation, a corporation only has limited powers to perform, and these limitations consist of those powers which are only provided for under the law and those which are necessarily incidental to these express powers. So we can classify corporate powers into three. The first is express powers. These are powers expressly granted or authorized by law, meaning these are powers which we can find in the Revised Corporation Code. These are powers which have been provided for by law in the Revised Corporation Code. Next classification is implied powers. What are implied powers? These are powers reasonably necessary to the exercise of express powers and to the accomplishment of the purposes for which the corporation is formed. In other words, implied powers are not powers provided or found in the Corporation Code, but can still be performed by the corporation for the reason that these are powers related to the purposes, to the functions for which the corporation is formed. And number three, incidental powers. Incidental powers are powers which a corporation can exercise by the mere fact of its being a corporation, or powers which are necessary to corporate existence. So incidental powers are related to the fact that a corporation exists, such as the power to use a corporate name, or the power to file an action against another person. So these are incidental powers because these are closely related to the fact that a corporation has its own life. So these are our three classification of corporate powers. We are going to discuss some express powers as provided in our Revised Corporation Code. What are these express powers? But in the meantime, let's take a look at this question. May a corporation embark on a business different from that which it was formed? When a corporation is registered, it is required to provide the purposes for which such corporation is being formed. In other words, the SEC will have to know for what purpose the corporation is formed. So if a corporation has provided for a specific business for its purpose, can such corporation conduct a business different from the purpose stated in its articles upon registration? The answer to this question is no, because a corporation is only allowed its existence by reason of the business for which it was purposely formed. So a corporation cannot, as a rule, perform other businesses outside of the business for which it was formed. So if a corporation is formed for the business of operating a coffee shop, industry or a coffee shop business. Such corporation can only do business as such a coffee shop. It can, of course, perform other related powers to that coffee shop business, like obtaining coffee bean supplies, obtaining creamers and sugar as additional ingredients in fixing up the coffee. But it cannot embark on a business that is entirely different and totally not related for the purpose for which it was created. So a corporation that is engaged in a coffee shop business cannot, as a rule, engage in the piggery business or some other unrelated business. Let us take a look at some express powers which we are going to discuss in this session. Some other express powers may be found in the Revised Corporation Code, but for purposes of our discussion, we are only going to limit the number of the express powers that we are going to discuss. The first express power is the power to extend or shorten corporate term. We already know that under the Revised Corporation Code, a corporation is given perpetual existence, meaning it can last forever. However, a corporation is also allowed to provide in its articles of incorporation that it will have a specific term. So if, let us say, a corporation provides in its articles to only exist for 50 years, then we can say that such corporation will have to automatically dissolve upon the 50th year. However, the corporation is granted likewise the power to extend this term by amending its articles, or it can even shorten such corporate term by amending the certificate of or the articles of incorporation. So this power to extend or shorten corporate term is a power granted expressly by the Revised Corporation Code to private corporations. Another express power is the power to decrease or increase capital stock. This is applicable to stock corporations in which such corporation is required to have a capital stock or the amount fixed in the articles as its capital. While there is no minimum capital stock required in the Revised Corporation Code, however, a corporation is required to state the amount as its capital stock. So once stated, that is the capital stock which will now be raised by the corporation. However, a corporation is also allowed to decrease this capital stock, and it may also increase its capital stock. Decreasing or increasing a capital stock may be allowed upon amendment of the articles of incorporation. Another express power is the power to deny preemptive right. What is preemptive right? We are going to talk about that in a little while. Another express power is the power to declare dividends, which is a very important, essential power in stock corporations. We are also going to discuss that in a little while. And lastly, the power to enter into management contracts. As I've mentioned, these are just 5 of the many other express powers mentioned in the Revised Corporation Code. You can just check the Revised Corporation Code for other express powers. But as I've said, for purposes of this discussion, we're only going to limit our discussion to these 5 express powers. Let us now go to the power to deny preemptive right. A corporation is allowed by law to deny the exercise of preemptive right. But first, let us take a look. What is preemptive right? So the principle of preemption or preemptive right of stockholders refer to that instance that whenever the capital stock is increased and new shares are issued, the new issue must be offered first to the shareholders who are such at the time the increase was made and in proportion to their respective shareholdings. Now, earlier we have said that one of the express powers of a corporation is to increase its capital stock. When you increase your capital stock, it means that you would also increase the shares of stocks that you can issue to several persons. So when the capital stock is increased and there are new shares, additional shares to be issued, the law requires as a right that if you are the stockholder, you have such right to be offered first these new issues. In other words, if you are an existing stockholder of a corporation, and if the corporation would decide to issue additional shares and thereby increasing its capital stock, these additional shares must first be offered to existing stockholders. Of course, the stockholder may choose not to accept the offering. What the law only requires that if you are a stockholder, you have this preemptive right or the right of first refusal, in which when new shares are issued and are being offered to stockholders, then the stockholders must be given prior right to refuse the new issuance. So stockholder, of course, may waive this right of first refusal, but when the articles of incorporation of such corporation provides that a preemptive right will be denied for every stockholder, then such right may be denied by the corporation. So the power to deny preemptive right can only be exercised by the corporation if it is specifically provided for in its articles of incorporation. But without such provision in the articles of incorporation, a corporation cannot deny the shareholder his right of preemption or right of first refusal. So the corporation may deny a stockholder his preemptive right through express provision in the articles. So in summary, class, if you are a shareholder, you possess this right of preemption or the right of first refusal, for which you can demand that whenever new shares are issued, it must first be offered to you before they can be offered to outsiders. Of course, if such shareholder would refuse to exercise his right, then that can be considered as a waiver. However, if the corporation has provided in its articles that preemptive right shall be denied for every stockholder, then that is a valid provision in the articles of incorporation because the power to deny a preemptive right is an express power of the corporation. Next is the power to declare dividends. As I've said, this is only applicable to stock corporations in which profit is earned by such a corporation. Trust fund doctrine. What is the trust fund doctrine? The trust fund doctrine says that the assets of the corporation, as represented by its capital stock, are considered as trust funds to be maintained unimpaired and to be used to pay corporate creditors. In other words, under the trust fund doctrine, all assets of the corporation shall be placed in trust as payment to corporate creditors. So such assets cannot be distributed among stockholders without making provision for the payment of corporate debts. In other words, once a corporation is formed, all of its assets must be reserved for payment to corporate debts, and such assets cannot be distributed to the stockholders if there is nothing left to pay for corporate debts. So any such disposition is a fraud of creditors and therefore void. Under the trust fund doctrine, if a corporation distributes its assets to stockholders without making a reservation or without reserving something enough to pay for corporate debts, shall be considered as a disposition that is void because they are considered to be made in fraud of creditors. So if a corporation would distribute profits to its stockholders without reserving certain amounts to pay to corporate debts, then that distribution of assets will be considered as void. It will not have any effect. because these are considered to be a disposition in fraud of creditors. Now, what is a dividend? Dividend is only a part or portion of the profits of a corporation that is set aside, declared, and ordered by the directors to be paid to the stockholders on demand or at a fixed time. So dividends is only a part of the profits and can only become such dividends when they have been set aside and declared and ordered to be released by the board of directors. So how are dividends distributed to stockholders? If a corporation earns profits and a portion of such profits have been declared as dividends, how much shall each stockholder earn or have a share in such dividends? So the law says that dividends shall be distributed to the stockholders pro rata. When we say pro rata, this would depend in proportion to the shares owned by such stockholders. So if a stockholder owns 10% of the shares in a corporation, once dividends are declared and are released, then such stockholder will have to own 10% of that dividends. Are profits considered as dividends? Are profits equivalent to dividends? If you look at this first part once more, we have learned that profits are only, or dividends rather, is only a part or a portion of the profits. So basically, profits are not considered as dividends. Who owns the profits of the corporation? Profits pertain to the corporation, is owned by the corporation under the trust fund doctrine, because again, a corporation is not allowed to distribute its assets, including the profits, if there is nothing that has been reserved as payment for corporate debts. So who owns the profits of the corporation? It is the corporation. So profits are not dividends until so declared or set aside by the corporation. We have just mentioned that profits are not equivalent to dividends. In the meantime, all profits are a part of the assets of the corporation and do not belong to the stockholders individually. In other words, if you are a stockholder and you learn that the corporation has earned profits, can you demand that such profits be distributed and be given to you as a stockholder? Answer is no. But you do not, as a stockholder, own the profits. It is the corporation that is considered as the owner of such profits. So if you look at this illustration, profits pertain to the portion which is in violet or purple, whereas a smaller portion thereof in yellow shall be considered as dividends. So dividends are simply a portion of the profits and can only be considered as such dividends and can only be distributed to the stockholders if they have been set aside and so declared to be distributed by the members of the board. Now, dividends cannot be declared until and unless it can be shown that there is still enough assets sufficient to pay for existing corporate debts. What are common classes of dividends? So there are different classes of dividends that may be distributed and declared. One, cash dividends. Of course, these are dividends which are distributed to stockholders in the form of cash. We also have property dividends. So a corporation may declare dividends to be distributed to stockholders in the form of property, whether real property or personal property. We have stock dividends. So these are dividends, of course, in the form of stock. And then we have optional dividend. An optional dividend is either cash or it can be stock upon the stockholder's option. So a corporation may declare the release of optional dividends, and when such optional dividends are declared, it is now the stockholder who has the choice whether he is going to receive such dividends in the form of cash or in the form of stock. As you can see, under optional dividends, the option is only between cash dividend or stock dividend. It does not include property dividend. And then we have composite dividends. For composite dividends, it consists partly cash, partly stock. So composite dividends pertain to part cash, part stock, but when it comes to optional dividend, it is only an option, a choice between full cash or full stock. We go now to intra vires versus ultra vires acts. We already know that a corporation under the limited capacity doctrine can only perform those powers which are expressly provided by law, impliedly, or incidental to its existence. What happens if a corporation performs an act which is already outside of the powers allowed by law? Will that act be considered as valid? So intra vires acts are those which are within the legitimate powers of a corporation. If a corporation performs an action which is within the powers allowed by law, then these are considered as intra vires acts. On the other hand, ultra vires acts are those acts which are already beyond or outside the conferred powers of a corporation or for the purposes for which it was created. In other words, ultra vires acts are of course those acts which is the opposite of intra vires, because these are acts which are outside the powers allowed by law to be performed by a corporation. So are ultra vires acts considered as illegal? An ultra vires act is not necessarily illegal, but an illegal act is always an ultra vires act. So for example, a corporation is formed for the purpose of engaging in the coffee shop business. If a coffee shop sells coffee beans, if that corporation engaged in the coffee shop business sells coffee beans to customers, then that is considered as an intra vires act because that is still within the legitimate powers of such corporation. But if such corporation engaged in the coffee shop business would engage in the piggery business, then we can say that that is already an action which is outside the purpose for which it is created, and therefore ultra vires. But does that mean that the corporation has engaged in an illegal act when it engaged in the piggery business, even though its purpose is only to engage in the coffee shop business? Answer is no. It is not illegal to sell pigs or to engage in piggery business. However, it is considered as ultra vires. So it may be ultra vires but not necessarily illegal. However, if that corporation which is created for the purpose of engaging in the coffee shop business engaged in the business of selling prohibited drugs, then that action of selling prohibited drugs is not only ultra vires because it's already outside the powers allowed by law and not related to the purpose for which it is created, but it is illegal. It is illegal to sell prohibited drugs, and therefore the corporation may be held liable for the commission of a crime in selling prohibited drugs. So again, an action may be ultra vires but not necessarily illegal. But once an illegal act is performed by the corporation, then it becomes automatically and always ultra vires. The second topic in this session pertains to bylaws. What are bylaws? Bylaws pertain to rules of action adopted by the corporation for its internal regulations and for the government of its officers and its stockholders or members. So when it comes to internal regulations, to internal conduct of the corporation pertaining to its officers, stockholders, and other members, then we have your bylaws. So when must the corporation adopt or enact its bylaws? It is allowed or it is required to adopt bylaws within 1 month after receipt of official notice of the issuance of its certificate of incorporation. However, take note that at present, when you register your corporation with the SEC, you do it online. And once the online registration is completed, you will now be required to download not only the articles of incorporation, but also including the bylaws. So automatic, when you register online with the SEC, you already have the bylaws. So there's no need to enact bylaws after 1 month from receipt of the certificate of incorporation, because bylaws are already included in the online registration. Let us try to distinguish articles of incorporation from bylaws. Articles of incorporation constitutes the charter or fundamental law of the corporation. It is executed before the incorporation, and it is considered as a condition precedent to corporate existence. On the other hand, when we speak of bylaws, they only refer to rules and regulations adopted by the corporation for the internal conduct of its business. It is executed usually after incorporation and therefore a condition subsequent. So articles of incorporation is the skeletal framework of a corporation, and bylaws would contain the additional details pertaining to internal functions of the corporation. The last topic under this session pertains to meetings. A corporation is required to hold meetings to conduct its business, and meetings may be regular meetings. For meetings of stockholders, it shall be made annually on a date fixed by the bylaws, but if not stated, it shall be held in April. So you have regular meetings of the stockholders or members of the corporation once a year. And then we have meetings of the members of the board, which must be conducted monthly this time unless stated otherwise by the bylaws. So regular meetings for stockholders or members are held once a year, but regular meetings of the members of the board are held monthly as a general rule. Other than regular meetings, we also have special meetings, and they are held anytime when necessary. Special meetings are called for urgent matters and for emergency purposes. In all meetings required by law, the presence of a quorum is always necessary. Without a quorum, the corporation cannot do business in its meetings. Who presides the meeting? In every meeting, the presiding officer is A. President, B. Secretary, C. Treasurer, D. Owner of majority stocks, or E. Philippine President. So the best answer is A. It is the president of the corporation who presides the meeting of such a corporation. This is the end of our session. I will see you again in the next succeeding sessions. Have a good day, everyone. God bless and stay safe.